Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Amber Duncan, and today I'll be joined by my colleague, Rob Van Arnam, a partner and chair of our IP section here at Williams Mullen, to discuss an advertising and promotion topic: practical compliance with the Telephone Consumer Protection Act. Rob focuses his practice on the licensing and litigation of IP rights and also counsels clients regarding privacy, data protection, promotion, and consumer laws. Hey, Rob, how are you doing today?
I'm good, Amber. Good to see you again.
Yeah, good to see you. So let's start with the basics. What is the TCPA and why should companies care about it?
Right. Good place to start. So the TCPA, the Telephone Consumer Protection Act, is an older law that has recent interpretation that are important for companies. So Congress enacted TCPA in 1991 to address aggressive telemarketing practices by placing certain restrictions on commercial solicitation calls, faxes, and other outgoing communications. Generally, most people were okay with that because it stopped, spamming and the things that were happening. Generally, it prohibits making any call or using any automatic telephone dialing system or pre-recorded voice to any telephone number assigned to a telephone service. So what that means is no robocalls without consent, a do not call registry. It requires companies to keep internal do not call lists, and also there's regulations on faxes. And then you asked, why companies should care, and why is it such a hot topic now? Well, most companies communicate with prospective and actual customers via electronic means, and communication is really the heart of how they are in touch with their customers. And there are significant fines and penalties for not complying with the act. One of the most significant things are class action lawsuits that have increased dramatically in the last several years, and some have reached over 75 million. There was a case against Dish Network that was 61 million in fines.
Interesting, Rob. I know you've talked a lot about these large class actions, so it sounds like a hot topic. So who regulates the TCPA? And since the act is about telephone communication, what about other forms of communication?
Right. Well, the FCC, Federal Communications Commission, is the one that enforces TCPA and also regulates telemarketing, although many states also have their own laws regulating telemarketing. The scope of the law has expanded greatly since 1991. Obviously, it's been interpreted to apply not just to regular old-fashioned phones, but to cell phones and text messages, which, of course, covers a wide scope now of communications from companies. And the FCC is the one that imposes fines. So I talked about private actions and class actions. Well, penalties from the FCC can be significant too. It can be up to $16,000 per violation, and in some actions can be $500 per communication. That means per text or call, and $1,500 per communication if it's willful.
Wow, that can certainly add up quickly. Now, previously you said the TCPA prohibits unconsented calls from an automated telephone dialing system. What is that, and how do you know if you're using one?
Right, that ATDS has been a hot topic and heavily litigated in the last couple of years. So that is equipment which has defined in law, has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. In 2015, the FCC had a rule and declared essentially and expanded the definition of what it meant, determining that the capacity to dial numbers randomly or sequentially meant that you had to comply with the law. In a case that interpreted that in 2018, the DC Circuit sort of threw out that approach and said that was overbroad. And really, since then, the circuit courts have been trying to wrestle with this issue because it greatly changes what it means to have an ATDS. The U.S. Court of Appeals facing this question have reached different results. And it's really almost a question of grammar, believe it or not, whether the modifier using a random or sequential number generator applies to both of the preceding verbs, to store or produce. And they've reached contrary conclusions, either by reading the modifier to apply only to the closest one. So that sounds like a grammar lesson, but it's a huge difference, because if it's capacity, then it's the extraordinary broad meaning of cell phones. For instance, any of our cell phones have the capacity to store lists of contact information. And therefore, a lot of companies would have to comply when they ordinarily wouldn't.
Wow, that's surprisingly broad. Rob, haven't I heard that the Supreme Court recently took up a case to resolve that issue?
Right. And trying to resolve this circuit court split, the Supreme Court last summer decided to grant cert, and actually just December 9th heard oral argument in a case with Facebook. It's called Facebook versus Do Good. And they're trying to resolve the circuit split on the issue of whether an ATDS encompasses any device that can store and automatically dial telephone numbers. It's kind of an interesting oral argument, and again, largely focused on grammatical and a strict interpretation of the statute, with Facebook and the government receiving generally friendly questions from the justices, and believing, I think, that the statute should be interpreted strictly and narrowly. And Brian Garner, actually famous legal scholar, was invited and gave oral argument. So it'll be really interesting to see, and I think the decision there will come out in either several weeks, but probably more likely a few months, and it will determine the full scope of the law.
So if you use an ATDS, you must have consent from the consumer, but how must the consumer manifest that consent?
Right. Good question. So the practical reason is, first of all, is since we don't know what the law is, you should assume you have an ATDS. Or if you have some form of software that could act like an ATDS, you need to get consent from your customers. And that's generally a good idea anyway, because people don't like to receive unwanted calls or texts. There's different forms of consent. So if you have a prior business relationship with a customer, they're giving you their phone number or allowing you to text for business purposes means there's implied consent, and you don't need something special for business related texts and communications. However, for any advertising or telemarketing, you need prior express written consent. And that means in writing, bearing the signature of the customer, clear and conspicuous disclosure of the authorization. And that's generally allowed now via website with a click-through agreement or other website communications that, again, though, that consumer has to specifically give consent and authorization to be called. The tricky thing here is dual purpose. So what is the nature of the call or communication? Is it strictly telemarketing, or is it partly for business and for telemarketing? If the call is motivated in part by the desire to achieve any future sale, the default is that you need consent, and it's also a telemarketing call.
Okay. So it looks like we're reaching the end of our time. What are the key points people should take away from today's presentation?
Right. So until we, hear from the Supreme Court, the first question is, are you using an ATDS? And if you're using a vendor to do it, do you have contract terms that protect you if, there's some later challenge and you don't have consent? Second, of course, is get the valid consent you need for the type of communication. Build that into your network, into your system, whether that's prior express written consent or just express consent. That will ensure that you're complying with the law. And keep those records, because it may be challenged later and you may be asked specifically for, in a class action challenge or something, did you get consent from folks? And that's something that you're going to need to know. Offer valid and effective opt-out options as well, and make sure that you're following up with people because they can always decide that they no longer want to receive those calls.
Great. Thank you for all this information today, Rob. It was very surprising and interesting. So that will wrap up our practical compliance with the Telephone Consumer Protection Act. I'd like to thank Rob Van Arnam for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. Until next time.